Good morning, everyone. My name is Andrew Mitchell. I'm a professor at Melbourne Law School, the University of Melbourne. My co-presenter in this session is Dr. Neha Mishra, postdoctoral fellow at the Centre for International Law, National University of Singapore. In our presentation today, we focus on the role of regional trade agreements in digital trade integration. We start with explaining what digital trade integration means from the point of view of international trade law and policy. We then explain that our framework for digital trade integration in regional trade agreements, or RTAs, focusing on 5 different foundational elements of digital trade integration. 1. Reducing digital trade barriers. 2. Digital trade facilitation. 3. Digital trade regulatory frameworks and digital trust policies. 4. Digital development and inclusion. And 5. Institutional coordination. In the next part of our presentation, using our framework, we will explore how different provisions in existing RTAs can or do contribute to digital trade integration. What we generally find in our exploratory exercise is that many RTAs, especially recent ones, contain relevant provisions that can help countries align their domestic laws as well as external trade policies pertaining to digital trade. However, their impact on digital trade integration is often not considerable, especially in facilitating digital inclusion, as well as addressing digital trade facilitation and digital trust that are relevant to least developed countries, or LDCs, and developing countries. Nonetheless, it is important to acknowledge that RTAs play a significant role in digital trade integration, especially given the inability of countries to negotiate digital trade reforms at the multilateral level at the WTO. One, however, needs to be conscious that conflicting approaches in RTAs on digital trade may fragment the regional and global framework for digital trade rather than strengthening it. In the final part of our presentation, we showcase some of our key recommendations and best practices for digital trade integration in RTAs. The digitalisation of the economy goes hand in hand with greater global connectivity through the internet and digital technologies and the exchange of information across borders. Countries are well aware of the benefits of digitalisation and therefore have a common shared interest in aligning their domestic laws and policies to facilitate more integrated rules, regulations, principles, processes and technologies in the digital trade supply chains. We call this the process of digital trade integration. It is evident that this process is complex and multifaceted and requires technology, legal and policy coordination in several areas of governance. Digital trade integration results in the free cross-border movement of not only digital services and products, but also manufactured goods, data, capital, ideas, and talent. It also means availability of integrated physical and virtual cyber infrastructure. Digital trade integration is not easy to achieve in practice, especially for LDCs and developing countries. Often such countries do not have adequate resources and regulatory capacity to integrate seamlessly in global supply chains like developed countries. This often leads to a digital divide. Further, political and regulatory differences among countries can also stand in the way of digital trade integration. This also raises difficult policy choices and regulatory costs for developing countries and LDCs. Countries must also find the correct strategic partners in their digital trade integration initiatives, especially within their regions. This means that often like-minded countries tend to group together in such initiatives, and the level of integration across different regional groupings can vary considerably. An important tool that governments use in achieving digital trade integration is international trade agreements. More importantly, as the WTO negotiations on electronic commerce have been rather slow, despite the recent joint statement initiative, various countries have relied upon RTAs to achieve this outcome. Such RTAs involve not only developed countries, but also many developing countries. In fact, RTAs involving only developing countries is also increasing. Most of the relevant provisions are contained in the electronic commerce chapters of such PTAs, although other chapters such as regulatory coherence, SMEs, trade in services can also be important in facilitating digital trade integration. Some of the key provisions that we cover in our presentation today are cross-border data flows, data localization, electronic signatures, paperless trading, cooperation in electronic commerce, and so on. This slide is a diagrammatic representation of our proposed framework on digital trade integration. We think these 5 pillars of digital trade integration are mutually supportive and interdependent. We also assume that the capacity of countries to achieve progress across each of these 5 pillars will vary considerably depending on their levels of development and policy choices. Let's look at the first, reducing digital trade barriers. Barriers to digital trade have an adverse impact on the economy as they lower consumer welfare and reduce possibilities for digital innovation. Many digital trade barriers are non-tariff barriers rather than customs duties, which is typical for manufactured goods. Some examples include burdensome licensing and certification requirements for digital products, mandatory Indigenous cybersecurity standards, especially for emerging technologies such as the Internet of Things, and restrictions on cross-border data flows. A very important restriction is data localization, requiring companies to store and process data within a country's borders. In other cases, data restrictions are less severe but nevertheless expensive to implement, such as burdensome certification requirements for data transfer or processing. Some regions, such as the EU, also face the problem of geo-blocking restrictions. Finally, some countries such as India, South Africa, and Indonesia have argued at the WTO that customs duties on electronic transmissions are necessary to preserve revenues of LDCs and DCs. However, it is likely that such duties will increase trade costs and reduce consumer choices and productivity without any substantial financial gains for LDCs and developing countries. Now let's turn to look at 2, digital trade facilitation. By digital trade facilitation, we refer to all measures that facilitate transactions necessary to conduct digital trade, including secure and interoperable electronic payment services, electronic signatures and authentication, logistics, especially small value shipments, and paperless trading. These factors are important to digital trade integration as they reduce trade costs and increase the speed, accuracy, and efficiency of electronic transmissions. A key change necessary to facilitate digital trade facilitation is that more countries adopt domestic electronic transactions laws. The UNCITRAL has set out a very helpful set of guidelines in this regard. It is especially important that countries refrain from imposing indigenous technical standards for electronic transactions, as they may reduce their security. We also think that digital trade facilitation is dependent on regulatory frameworks such as privacy and cybersecurity, which we will discuss next. 3. Digital trade regulatory frameworks and digital trust policies. This pillar covers all domestic measures relevant to digital trade or those that foster digital trust at an institutional or business or individual level. Some of the main areas are privacy and data protection, online consumer protection, cybersecurity, spam, competition, and intellectual property. Conflicting frameworks reduce trust in digital technologies and make it extremely difficult for smaller companies and individual entrepreneurs to compete in the global market. Finally, many LDCs and even several developing countries do not have sufficient resources to develop regulatory frameworks. This in turn may also affect the security and integrity of cross-border data flows and electronic transactions. Various initiatives exist in different organisations on regulatory coordination and coherence in many of the above areas, but the involvement of non-state stakeholders has so far remained negligible. This could be a problem because Various technical standards and best practices on areas such as cybersecurity, privacy, and online consumer protection are often developed by the industry or internet technical bodies such as W3C or IETF. In developing regulatory frameworks on digital trust and digital trust in a manner that focuses on digital trade integration, countries must focus on three aspects: transparency, interoperability of technologies, as well as policy frameworks and greater regulatory coherence, for example, by using relevant international guidelines or principles as a point of reference across all domestic institutions. 4. Digital development and inclusion. Ultimately, digital trade markets will only grow when more people participate in the global digital value chain. Thus, reducing digital disparities within and among countries is both equally important. This would require a mechanism of robust domestic policies as well as strong international cooperation mechanisms. Unsurprisingly, policy action on this front has generally remained weak. However, different stakeholders now recognise the importance of digital development and inclusion in developing a strong and integrated digital economy. 5. Institutional coordination. Institutional coordination is essential to digital trade integration because regulatory cooperation and monitoring the implementation of digital trade policies and agreements are both essential to achieving digital trade integration. It is perhaps not surprising that institutional mechanisms to facilitate digital trade integration are generally quite weak and usually do not involve non-state institutions or public-private collaborations. But collaborations in many areas pertinent to digital trade integration, such as setting high-level principles and guidelines and technical standards setting, are increasingly necessary. Even adequate information exchange among trading partners can expedite the process of digital trade integration. The next question is how RTAs contribute to the 5 different pillars of digital trade integration. We start with the first pillar of reducing digital trade barriers. Some RTAs contain obligations on non-discrimination, i.e. most favoured nation treatment and national treatment that apply to digital products. Some examples include the Singapore-Australia Free Trade Agreement, the CPTPP, the USMCA, and the Peru-Australia FTA. However, overall, the number of PTAs containing binding non-discrimination obligations applicable to digital products is only about 20. Obligations on non-discrimination can play a key role in levelling competition in the digital trade market, as many digital trade barriers, such as data localization, are likely to be caught by such obligations. Similarly, several recent RTAs contained obligations on cross-border data flows, requiring countries to allow the free flow of data necessary for the conduct of e-commerce businesses and prohibiting countries from imposing data localization. These two provisions are usually subject to an exception that permits restrictive measures if they're necessary to achieve legitimate policy objectives. The first RTA to contain a binding obligation was the TPP, but since then we have seen similar provisions in other RTAs of Australia. Here we've got the example of the PAFTA, Japan, the US in the USMCA, and Singapore, Sri Lanka FTA and others. However, so far only 28 RTAs contain provisions on data flows, of which only about half of them contain binding obligations. About 77 RTAs contain provisions that prohibit the imposition of customs duties on electronic transmissions. Coming to the second pillar, we see an increasing number of RTAs focusing on different aspects of digital trade facilitation. Recent RTAs often refer to the UNCITRAL model laws on electronic signatures and electronic contracts. They also recognise electronic signature and authentication methods. Some examples include the CPTPP, the USMCA, the US-Peru FTA, US Mercosur Agreement, and others. Some RTAs, such as the CPTPP and DEPA, go further. They require that electronic authentication methods of parties must be interoperable. Paperless trading provisions are not very common to RTAs, and even in advanced RTAs such as the CPTPP and the USMCA, these provisions are not binding. Cross-border logistics and electronic payments are both important for digital trade facilitation. A rare example is the Digital Economic Partnership Agreement, which covers both these aspects, albeit through soft provisions. It is important for trading partners to share information on cross-border logistics, especially to facilitate small value shipments for MSMEs. Similarly, for electronic payments, the DEPA provision is critical because it recognises the need for robust international standards in this industry, especially for small players in emerging economies, and the use of electronic KYC and verification to reduce trade costs. It remains to be seen, however, if least developed countries and developing countries can use regulatory sandboxes to facilitate innovations in electronic payments. RTAs are increasingly being used by countries to facilitate different aspects of the digital trade regulatory framework. At the outset, we note that RTAs cannot set standards for areas such as privacy, cybersecurity, and online consumer protection. However, RTAs can incentivise countries to adopt basic minimum regulatory frameworks to increase digital trust among trading partners consistent with international guidelines or standards. It is also an essential precondition for cross-border data flows. Perhaps the most discussed issue in this regard is data protection and privacy. The early generation RTAs mostly recognised the importance of cooperation on data protection, but they didn't go beyond that. However, as digital trade has grown, privacy has become more central to electronic commerce chapters in RTAs. Some RTAs, such as the CPTPP and many others that follow the same model, require all parties to adopt basic legal regulatory frameworks for protection of personal information, but they're usually lenient regarding what constitutes a legal framework for personal data protection. For example, self-regulatory approaches and ad hoc sectoral approaches also qualify within this provision. The CPTPP also encourages parties to develop mutual recognition mechanisms so as to facilitate cross-border data flows. However, it is unclear what happens when two data protection systems are very different. Many experts criticise the CPTPP for being too lenient. We see some changes in more recent agreements, such as the USMCA and the DEPA, which require parties to adopt a legal framework consistent with international guidelines from the OECD and APEC. The DEPA also recognises the APEC CBPR as being critical for the transfer of cross-border data flows, as well as encourages the adoption of data protection trademarks. All of these factors can support digital trade integration. This is in contrast with the EU approach, which provides a carte blanche for countries to adopt a privacy framework as every country deems fit. RTAs also increasingly take note of issues of online consumer protection, cybersecurity, and spam. While an increasing number of RTAs refer to online consumer protection in their electronic commerce chapters, very few of them contain hard provisions such as the USMCA, the CPTPP, the EU-Mexico Global Agreement, and several Australian FTAs. The DEPA also contains a provision that recognises the importance of ADR mechanisms for resolving e-commerce disputes. About 40 RTAs contained high-level provisions on cybersecurity cooperation. They are unlikely to do much to ensure digital trade integration unless parties use these cooperation mechanisms with strong political will. This is a missed opportunity. as trading partners have several incentives to cooperate on issues such as containing cybersecurity threats and technical standards. We also do not see any mechanisms for cooperation with other institutions, such as the ITU. We think it would be fair to say that RTAs have largely failed to include critical aspects of digital development and inclusion. Some RTAs, such as ASEAN Agreement on Electronic Commerce, allow for staggered implementation of commitments for LDCs and some developing countries, but where RTAs fail the most is setting up a coherent program for technical assistance and capacity building. While domestic policies play a predominant role in digital development and inclusion, RTAs can be an important tool to foster cooperation among trading partners in digital development and inclusion. Further, although it's very rare, the DEPA has focused on digital inclusion of minorities, especially in relation to trade and gender issues. Even if RTAs contain strong provisions on digital trade integration, their implementation and monitoring both require strong institutional mechanisms. Unfortunately, most RTAs do not set up a central coordinating institution that can deal with e-commerce issues with regard to all of these aspects. Some rare exceptions are the DEPA and the ASEAN Agreement on Electronic Commerce. The EU-Japan EPA and the ASEAN Agreement on e-commerce set up a mandatory international cooperation mechanism between the two countries on issues of consumer protection, cybersecurity, spam, e-commerce development, electronic signatures, SME-related issues, IP, and e-government. Such strong provisions can play a very positive role in digital trade integration. We would like to end our presentation with some best practices and recommendations drawn from our study of current RTA practices on digital trade and electronic commerce. The first is binding provisions on cross-border data flows and prohibitions on data localization with reasonable exceptions. The CPTPP model has been replicated in many recent RTAs, and we think that this will play a positive role in digital trade integration. We, however, argue that exceptions to such provisions need to be clear, flexible, and reasonable. Although it may be prudent to leave open a list of legitimate public policy objectives, a list of illustrative examples of such objectives may reduce uncertainty. It is also important to remember that provisions on data flows can only operate in an environment of digital trust. Thus, digital trade regulatory frameworks on privacy and cybersecurity must also be robust to support a liberalised environment for cross-border data flows. 2. Non-discriminatory treatment of digital products. No customs duties on electronic transmissions. It's important to avoid unnecessary restrictive conditions for players in the digital trade market, especially MSMEs. It is also ideal if such provisions apply to all digital products, such as the debate on digital goods versus services has been a key factor stalling the WTO work program on electronic commerce. 3. Binding provisions on electronic signatures and paperless trading. The increasing importance of digital trade facilitation, especially from the perspective of LDCs and developing countries, is clear. Electronic transactions can reduce trade costs and increase efficiencies for all RTA parties. It is also important that the standards used are based on international guidelines and remain interoperable. We also recommend that RTA parties can consider provisions on cross-border logistics and electronic payments, as was the case in the DEPA. 4. Disciplines on data protection, including data certifications, trust marks, cross-border consumer protection, and online dispute resolution. We recommend that RTAs play a facilitative role in the development of regulatory frameworks on digital trade. Parties should also adopt basic frameworks on data protection, cybersecurity, consumer protection, etc., But trade agreements should not set specific standards. Rather, they should incorporate international standards by reference. The problem is, however, conflicting standards and guidelines internationally. One way of dealing with this limitation is to encourage mutual recognition agreements. For example, the EU-US Privacy Shield with two very different privacy models. 5. Mandatory technical assistance and capacity building in RTAs. LDCs in developing countries may need additional time to implement commitments on electronic commerce in RTAs. We think such provisions should be incorporated to encourage more participation from LDCs in RTAs. However, for digital trade integration, LDCs need support from their developing and developed country partners. We don't see such mechanisms in RTAs and thus consider it an important area of reform. 6. Institutional mechanism. In order to increase digital trade integration, we think that RTAs must develop a single coordinating body that can perform various functions, such as facilitating information sharing and cooperation, organising technical assistance, including funds from developed countries, regulatory support programs for LDCs, and monitoring implementation of e-commerce provisions in RTAs, and developing institutional networks with relevant bodies. We thank you very much for your attention and look forward to your questions.